Reproductive Justice and the EU, Global Comparative Insights. A conversation on reproductive justice is urgent in a global context in which access to abortion is under threat around the world, and we are witnessing the normalization of political agendas aiming at curtailing reproductive rights. My name is Costanza Emanin, and I'm connecting from the Robert Schuman Center at the European University Institute. This webinar is part of the Global Gender Equality Seminar Series, a format developed by the Berkeley Center for Comparative Equality and Non-Discrimination Law and the Global Governance Program at the European University Institute in Florence. I would like to thank Professor Ivana Izailovic for promoting this appointment and taking care about its scientific organization, my colleague Furaha Joy Sekai Saungweme, who is connected and directs with me the Gender Justice Group at the Berkeley Center, Mia Sagman, Charlie Tsunoda, and Daniel Ramos for their crucial organizational support. Our guiding question today is, what does a robust reproductive justice legal framework look like? And what are the limits of the law? So we will address this question by looking at different areas of the world and legal orders, national and international, and bringing comparative insights to the analysis of the situation, especially in the EU, which is the place from which we're going to start. In fact, while the EU is often perceived as being at the forefront of gender equality issues, reproductive justice, and in particular access to abortion, has been the blind spot of the EU's action until recently. In fact, in the aftermath of the US Supreme Court decision in Dobbs in 2022, several member states, most notably France, and EU institutional actors, most notably the European Parliament, and civil society organizations, I will mention the Your Voice, My Choice campaign, have engaged with the future of abortion in the EU and the limits of EU law and policy. So as a member of the campaign I mentioned, I will say a couple of words about it later. But now let me turn to introduce our today's speakers. They are going to speak for 10 minutes each, and we're gonna have a discussion and the possibility to answer a question in about 45 minutes from now. So our first guest is Ivana Izailovic, who is assistant professor at the University of Amsterdam and co-leader of the Sustainable Global Economic Law Project. Second is Professor Aziza Ahmed from Boston University School of Law. A third guest is Joanna Erdmann, a professor at Skolkage School of Law, Dalhousie University in Halifax, Canada. And our fourth is Mariana Prandini Assis, who is a faculty member at the Universidade Federal de Goiás in Brazil and a human rights lawyer. So let me turn first to Ivana Izailovic for her presentation, focusing on how the EU regulates abortion through economic and human rights frameworks and her criticism of that. I don't want to anticipate anything, but the floor is yours, Ivana, for 10 minutes. And thanks for helping us organize this.
Thank you first. Hi, everyone, and thank you for joining us for this webinar. I want to thank Joanna, Aziz, and Mariana for joining the conversation, and I want to thank Costanza and Joy, as well as the Berkeley Center on Comparative Equality Law and the UI for organizing, helping with the organization and co-hosting this event. So I'll start by saying a few words about the situation in the EU. In a paper that was recently published by the Columbia Journal of European Law, I argue that to a large extent, EU law undermines reproductive freedom. It shields member states' laws from direct scrutiny, no matter how harmful these abortion laws are, and creates a system of stratified reproductive freedom, protecting those within the EU who are mobile, who have resources and networks that allow them to obtain abortion abroad. Overall, it creates a system where some, provided that they have financial resources and can internalize the costs, have option to exit member states' healthcare systems, and others who are either coerced to continue unwanted pregnancies or are incentivized to carry out a clandestine abortion. So in some existing legal and policy frameworks in the EU are to a large extent part of the problem. And this risks, and it is disproportionately affecting women and pregnant people from marginalized communities, so immigrant racialized poor communities. So how does EU law undermine reproductive freedom? So first, EU constitutional frameworks protect the laws of member states regulating abortion. And here's why. One reading of abortion is that it is a health issue. And as such, it is within the exclusive competence of member states. And while the right to health is protected by the European Charter of Fundamental Rights, the latter has only very limited effect. It only applies if member states are implementing EU law, and it cannot change the distribution of competence within the EU. And finally, the Court of Justice of the European Union has emphasized repeatedly the autonomy of the EU legal order vis-a-vis international human rights that guarantee access to abortion. All of these structural limits illustrate a deeper point argued by many EU scholars, and that the EU has never truly meant to be, was never truly meant to be a human rights organization, and is highly ambivalent about it. And that EU actions are severely constrained in this field by the EU constitutional framework. But the EU law regulates abortion and legitimizes inequalities in another way. In the early 90s, the Court of Justice of the European Union found that abortion is an economic service, and that means that transnational recipients and providers of abortion services are protected by EU fundamental economic freedoms. And to a large extent, the EU has limited the capacity of member states to limit cross-border circulation of economic services. And some experts have argued that it would be impossible for a member state to prohibit the distribution of abortion pills via telemedicine across member states. Now, some legal scholars are have argued that within this context, EU market rules could provide a site for gender emancipation and be more effective, actually, than EU human rights and European human rights, broadly speaking. But as many feminists and critical race theory scholars argue, there is a danger in quoting abortion as an economic service, as essentially a contract between a provider and a patient. They showed how markets in capitalist and neoliberal economies are inherently unequal, gendered, and racialized. And in this case, in the case of the EU, coding abortion as an economic service risks privatizing, so on the one hand, reproducing inequalities, but also privatizing and depoliticizing the issue of abortion, isolating it from structural policies and the reproduction of hierarchies. I argue that today, EU economic law creates what I call the private transnational self-government system, where those who are able to, those who are educated, wealthy, and mobile, can cross borders and get abortion abroad or get abortion pills from abroad. And those who are not able to exit their home states are without recourse under EU law. But even those who have financial resources and other resources to travel abroad, this comes at a cost. Traveling for abortion can be a distressing experience, placing those who travel outside their familiar environments and could deprive them from the care and the support that they need. So given all these structural constraints that I mentioned, where law I argue both human rights law and economic law are to a large extent part of the problem, are there any ways to translate within EU law and policy a more capacious understanding of reproductive justice? And here are some tentative answers, and I'll stop with that. First, any such conversation need, I think, to start to be embedded within the context in which member states have a long history of discrimination against racialized immigrant and poor women, and have been substantively limiting their reproductive freedoms. Second, designing any new solution will require being attentive to how neoliberal logic that underpins EU economic model constrains states and individuals and reproduce gendered and racialized exclusions. So any new solution, I think, will need to try to find a way to transcend this knowledge that is deeply ingrained within EU governance. And third, the participation of feminists and reproductive justice activists and civil society who are aware of the situation on the ground and who are aware of all the obstacles that people are facing is crucial. And especially in a context in which well-organized transnational conservative movements are deploying law, including human rights law, and EU constitutional law to fight against any progress in terms of gender equality. And Constanza will later talk about the initiative My Voice, My Choice, who is an initiative coming from feminists and civil society. So this being said, in my article, I explore some tentative, alternative, and very limited pathways to achieve a more robust legal framework within existing legal constraints. And I argue that one solution could and should be grounded in the materialist reading of human rights, repeatedly affirmed by international human rights bodies, and according to which states need to ensure that access to safe and effective abortion is guaranteed, and that states need to be attentive to material conditions and guarantee that the material condition and guarantee that intersectional inequalities are not reproduced. This, I argue, should inform the interpretation of the European Charter for fundamental rights, which applies to all legislation and all policies, EU policies, including, I argue, the application of economic regulation related to supply and access to services, as well as the redistribution of funds within the EU when it comes to health, and just to name a few. But many of these changes are, as I said, very limited and maybe impossible in the current context in which conservative parties are largely dominating the EU. So maybe there's something about transcending law and policy altogether, but I will let also Mariana talk and Aziz and Joanna talk about that. So I leave it here and Aziza, the floor is yours.
Thank you. Thank you very much, Ivana. A lot of food for thought. I think the discussion could be engaging. I'll yield the floor right away, however, to somebody who can explain to us, outline to us the broader context, especially across the Atlantic. Aziza Ahmed, you, I mean, in your work, examined the intersection of law, politics, and science in the fields of constitutional law. So where best could we start our analysis from, especially given that we started our reflection from the US Supreme Court decision in Dobbs and the political environment context around it. So Aziza, the floor is yours again for 10 minutes to give us this context. Please.
So much. Thank you so much, Costanza, for moderating and planning, and Ivana, to you for all the great events that you're always planning and keeping these wonderful conversations about feminism and gender going. My own work, as Costanza mentioned, is really on the way social movements mobilize science and scientific rationales in their legal reform projects, as well as how the courts are sort of grappling with these questions of science and expertise, especially in the case of gender and health. A lot of my work is on abortion, and I have a forthcoming book in September, finally, called Risk and Resistance, How Feminists Transform the Law and Science of AIDS, which is really about how social movements disrupt settled science in service of legal reform and redistribution. So my comments today, though, are really kind of inspired by Ivana's excellent blog post on LPE, on the Law and Political Economy blog, which we circulated among us before we planned our presentation. It might be helpful for people to add a link to it, Ivana, in the chat, because it is an excellent post about what's happening in the EU. And in that post, Ivana really thinks a lot about the way the idea of the market is being mobilized in the context of the EU and abortion access. And that got me thinking a little bit about how the market, or the idea of the market, features in US advocacy and constitutional discourse. And I thought, just for the sake of our conversation and sort of laying out a framework here, I would point to 3 different examples of where I see sort of the market and the idea of the market playing a role in abortion advocacy, as well as in decision making by the courts. The first is really to note that discourses about that the discourse around markets in the United States, or like that there's a slight difference in how we might understand how discourses of markets play a role in constitutional litigation in the United States, separate from the EU. And that's because when we talk about abortion access in the United States, and in particular when we're thinking about abortion access for women who are being excluded, really the framing has not been of markets or as poor women as market participants, but actually as dependents on the state, or people who are seeking entitlements from the state. And this logic of dependency really taps into a long, long history of discourse around welfare in the United States, which is, of course, then further conditioned upon and sort of mired in a broader debate and discourse about who the deserving and undeserving poor are. Now, needless to say, there is huge amounts of reproductive access inequality in the United States around abortion. This was true before Dobbs, especially for poor women, especially for women of color. It was also true that, criminal prosecutions occurred before Dobbs, and certainly has been heightened immensely after Dobbs with regard to women, especially for women with a lack of health insurance, who are located in states which now have outright bans on abortion, which for racial minorities, and for women without access to financial resources or the sort of resources needed to travel to receive an abortion in the United States. A steady job, the ability to take time off, the ability to pay for the auxiliary service, auxiliary needs like hotel rooms, etc., all of which has been discussed by the Supreme Court in a later set of cases. And many women do not, as I mentioned, have legal access to abortions in the states that they lived in. Now, there have been a lot of attempts to sort of access abortion to, really broaden the ability to access rights. And, again, these cases go to how the question is always framed as a question of dependency rather than a question of markets. So, for example, in the 1977 Supreme Court case, Meher v. Roe, a plaintiff challenged a Connecticut law that banned the use of Medicaid funds for non-medically necessary abortions, and the court held that a state is not obligated to pay for non-medically necessary abortions simply because it's paying for pregnancy-related services. In other words, Connecticut was under no obligation to pay for the abortions of poor women because the ban was rationally related to a strong and legitimate interest in encouraging childbirth. Here, too, we see how even in these early cases, forced pregnancy is an acceptable way to utilize power over those claiming resources from the state. So people seeking abortions are not understood to be market actors in the way that we might be seeing this conversation occurring in the EU, but instead really dependence. Now, the anti-poor element, the sort of dependency theme, is further emphasized with the 1980 case of Harris v. McRae, which relies on the Meher v. Roe holding. The plaintiffs here sought to challenge the application of the Hyde Amendment, which is a ban on federal funds to reimburse the cost of abortions under Medicaid. And the court here found that the Hyde Amendment served a rational government purpose to preserve the life of the fetus. And the court held that states participating in the Medicaid program are not obligated to fund those medically necessary abortions where federal monies are not permitted for reimbursement. And the court explains, and I really always teach this language because it's so profound, although the government may not place obstacles in the path of a woman's exercise of her freedom of choice, it need not remove those of its own creation. Indigency falls in the latter category. The financial constraints that restrict an indigent woman's ability to enjoy the range of constitutionally protected freedom of choice are not the product of governmental restrictions on access to abortion, but rather of her indigency. So essentially, the court is saying the state does not cause poverty. Women are poor of their own making. And when a woman is poor of her own making, the government has no obligation essentially to pay for her abortion, making this a right essentially that poor women cannot exercise. Lawyering has pushed forward despite the fact that the possibility of using the courts to actually accomplish some redistributive goals would be unsuccessful. Lawyering, I think right around this time, I would say, really diverged from a sort of anti-poverty, sort of pro-welfare rights perspective to a more constitutional register in which we were thinking about privacy, etc. And again, in this conversation and in this context, the idea of poor women sort of falls to the wayside in a constitutional register. Now, this gets softened a bit and fixed a little bit in the context of June Medical and Whole Women's Health, which have now been essentially undermined with Dobbs. But in those decisions, again, we saw the court sort of noting that actually poor women are unable to access the healthcare that they need, that the state restrictions on abortion are providing a substantial burden and making it impossible to access abortion-related services. The second place where I see sort of the market frame sort of come in and out of play is in reference to women as workers. And this really appears in a lot of amicus.
Yes.
Oh, sorry, should I stop? Two, oh, three. Okay, all right, I'll go quick. This is the idea that really lack of access to abortion can impede a woman's workforce participation. These arguments typically echo in the register of the Equal Rights Amendment and sex discrimination. For feminists, this line of argumentation has been really important. The idea that a lack of access to abortion impacts our ability to participate in markets, even though in Dobbs, Alito, of course, cast away the idea of the relevance of the Equal Rights Amendment very early on in the decision. And finally, I thought I would end by just noting a connection between some of the way we're talking, some of the ideas that are circulating around markets and some of the work that I've been thinking about around science. And this is that we can track other conversations about markets and the abortion context in the United States. For example, the repeat attempt to bring mifepristone to market in the early days of the drug approval process. And here we have reproductive health and feminist advocates really aligned with the desire to bring mifepristone to the United States by pharmaceutical companies, in part at least due to the sort of profit incentives that are associated with wide use of mifepristone, or at least the possibilities of. And this has really been documented by R.L. Tocharo in some of her work on sort of the politics around mifepristone access. But here, of course, bringing an abortion medication to market gets mired in an anti-choice politics in the United States, which is then filtered through the drug approval process in the Food and Drug Administration. And so from the get-go, this meant that anti-choice advocates are sort of deploying a series of arguments in a public health and scientific register that mifepristone is unsafe, and have continued to do so for the past 25 years. Of course, there's many cases now we can talk about with regard to that, but which will, of course, impact the ability to access and is impacting the ability to access the drug. So here again, science becomes more relevant, I think, to the discussion of basically how to think about a market in the context of abortion, and probably begs a broader conversation about how assertions of market rationales and science are sort of cloaked in the veil of expert claims and neutral assertions, that make access to abortion possible or not, and refract through a various different set of discourses that are sort of, in some contexts, uniquely American, especially where it intersects with the anti-welfare, anti-dependency politics here.
Thank you very much, Aziza, also for respecting the time. From your intervention, giving the floor to Joanna Edman comes very naturally, because Joanna is going to continue discussing the relation about poverty, abortion rights, and the economics of reproduction, but looking, instead of a specific country, looking at international law, and especially the UN human rights system. So Joanna, we yield you the floor for the usual 10 minutes. Thank you.
Great. Thank you so much, especially for bringing us together today. So maybe I'll come back to the prompt, which was, from the view of abortion rights in the EU, what would be a robust legal framework? And I'm sure I could have found many proverbs or parables or whatever about feared things that carry hidden value. And I think this is also true of legal histories. And it's why I just loved Ivana's work of recalling the EU history of abortion rights as economic services and tracking its legacies and also its harmful effects today. I think it's a necessary, but also a really generative critique. And the reason why is because it absolutely brings us to the economics of reproduction, which frankly, all of human rights law has engaged just far too little. And this is true despite economic thinking being central to the history of abortion rights, including in international human rights law, UN treaty-based law. And the reason why is because the ICPD is, of course, the often cited origin of sexual and reproductive health and rights. But in the sense of these forgotten histories, less cited is the fact that the ICPD completely reconceived the relationship between reproductive rights and economic justice. This is not cited as much. But frankly, in the population control paradigm, fertility was seen as necessary for economic growth. Family planning was used to eradicate or reduce poverty. And the ICPD completely flipped this paradigm and instead emphasized economic restructuring of reproductive life in the human rights to safe homes, secure livelihoods, social protection. This was an incredible turn of the ICPD. And so the question for us is, what happened to that history? Where did it go in human rights law? Rosalind Pachensky wrote for years, don't lose it, don't lose this history, and wrote and asked again and again, what are reproductive rights if they're not connected to economic justice and an end to poverty? So this is a history lost to be regained. Now, over the decades, abortion rights in international law, they found expression as many rights: life, health, freedom from discrimination, freedom from mistreatment, special measures of protection. Eventually, just last year, abortion rights as a simple fundamental human right. But remarkably, abortion rights have never been the right to be free from poverty. And I say remarkably because poverty is everywhere in the abortion rights jurisprudence of international law. And why? It's there because almost all of the case law of abortion rights in international law involve young, poor girls living in Latin America. In other words, it's not truly international law, it has a regional specificity. They are, quite frankly, the authors of abortion rights in human rights law. And again, it's not just that they live in Latin America, which of course is a region already marked by extreme wealth inequality and economic fragmentation, but these girls, if you follow their lives and actually see the names of their towns, their districts, the provinces, those are places that are marked by structural injustice. You have overstretched public services, underinvested public infrastructures, little state presence. They are places where growing up as a young girl carries strong gendered expectations of vulnerability to violence, burdens of care, and systemic neglect. Now, these are not simply the underlying economic conditions of access to abortion care. No, these are the very conditions of reproductive life and living. And they shape people's decisions about whether or not to continue a pregnancy, to end a pregnancy, to have or care for a child or another child, and the consequences of all of those decisions for themselves and for others. What's fascinating in these communications is that most of the young girls are minors. And so as a consequence, their mothers are very present in these communications. The mothers claim human rights violations on their daughters' behalf, but they are also claiming human rights violations for their own burdens, their burdens of caring for children, their daughters, and the daughters of their daughters when the state will not. So the economics of motherhood are everywhere in the jurisprudence. They're measured by lifetimes of deficit and dependence. Poverty is everywhere in abortion rights jurisprudence, but never is economic justice an abortion right or remedy. And so, very much like EU law, instead, I think abortion rights in international law can be critiqued for absolutely the privatization of poverty. This primarily happens through medicalization. Poverty is pathologized as a risk or an aggravating factor in pregnancy, and then abortion care is a health right. And this is, again, interesting. It's a health right to relieve often the mental distress and suffering of having to parent in poverty, or of these children having to impose another economic burden on their family. If not framed as a medical decision for poor people, then abortion care is framed as a rational decision for poor people. It's a private right to control your own life free from state interference. In these readings, abortion is a form of social security, means to access education and work, a means to mitigate the harms of sexual violence. Frankly, it's a means to survive economic injustice, even if human rights law would never admit to that instrumentalization of reproductive bodies and acts. But of course, all of these framings of abortion rights express, as was already noted, anti-poor ideologies of stratified reproduction, and they also naturalize reproductive precarity. In these readings, there's no state accountability for economic injustice. There are only the rights and remedies to survive it. Rachel Trebuchet once wrote, and it was a beautiful articulation of this kind of problem, this dilemma in human rights law. Rachel wrote, if abortion is a critical act to get out of poverty, then the next step is to understand the structures that configure abortion as poverty reduction. And I absolutely agree that this is the way forward. Human rights law has to attend to the economic value of abortion care in the lives of people. More broadly, it has to attend to the economics of reproduction. These are the structures that make pregnancy unwanted, the structures that distribute care needs, and all of this requires public, not private action. Abortion rights have to reach state responsibility for reproductive life, together with the right of people to control their own. And to conclude, I'd say international human rights law is turning that corner. There are a set of very, very recent abortion rights communications. One was just released, I think, a few days ago. And they focus on the lives of these poor young girls who claim their rights, but not just as the lived conditions by which they became pregnant or the conditions by which they are seeking access to care. Instead, it's about the whole life trajectory, which in many of these communications, tragically, is seen by the girls themselves as a life not worth living. They would rather die than become a mother. Now, in these communications, the right to abortion is framed as the right to life. But very different than the past, this is not a right to avoid death because of maternal risk or unsafe abortion or even suicide. Instead, it's a right to live with dignity, which is defined as the ability of a child to choose and carry out a life plan, and the duty of the state to take care and promote that life plan, to accompany the child in life. The abortion right of these communications absolutely borrows from concepts of childcare in human rights law, but childcare as a state responsibility, a public responsibility calling on the state to sustain the conditions of life through public investment, infrastructure, and redistribution. So last line here, abortion rights are about a care economy. They're not simply inseparable from economic rights. No, this is an abortion right, which is the right to be free from poverty. And I'd say even more so, it is the right to a new economic order, which recognizes reproduction and care as the basis of life in society. So absolutely, let's take that path forward. Thanks.
Thank you. Thank you very much, Joanna, for the engaging presentation. I'm giving the floor now to Mariana Prandini Assis. She is going to keep the flow going, but to focusing on a slightly different topic, but absolutely complementary, which is the centrality of social movements in adapting in advancing reproductive justice against the framework, the backdrop of state and international institutions action and the relative legislative framework, with a special focus with examples from Latin America. So Mariana, the floor is yours again for 10 minutes, and thanks for being with us.
Yeah, thank you. Thank you so much, Ivana, for the invitation, along with Constanza for organizing this fantastic panel. And thanks, Mia, for the logistical support here. I'm truly honored to be here among people whose work I admire deeply, and some of whom are also very dear friends. So in my remarks today, I want to problematize this opposition between market and state, including state-based institutions such as human rights body. So instead, I want to propose the multi-actor approach that foregrounds the central role of social movements in advancing reproductive justice. And I'll try to bring some examples from Latin America and the Caribbean to show how movements have been keen here to contesting both institutional bureaucratization and market-driven commodification, and articulating alternative visions of abortion care, visions that resist reducing it to either a liberal legal right or as a consumer good. So I'll begin with some brief regional context for those of you who do not know much of the legal landscape in Latin America. So in 2018, the Guttmacher Institute estimated that over 90% of people of reproductive age in Latin America and the Caribbean lived in countries where abortion was either completely prohibited or permitted only to save the pregnant person's life or to preserve their physical or mental health. And at that time, only a handful of jurisdictions, Cuba, Guyana, Puerto Rico, Uruguay, and Mexico City, had legalized abortion without restrictions as to reason, but still maintaining gestational limits. Since then, since 2018, however, we've seen a significant transformations throughout the entire subcontinent. So several countries, including Chile, Argentina, Colombia, Ecuador, have liberalized their abortion laws to more or less extent, either through legislation or constitutional court rulings. And then, so from being one of the most restrictive regions in the world, Latin America has become the epicenter of Marea Verde, the green scarf movement that flooded the streets, demanding reproductive rights and justice. But at the same time, the region has not been immune to calls for reducing the role of the state in providing basic services, such as healthcare. On the contrary, we all know Chile was the very first laboratory where neoliberalism was implemented. And as Ivana rightly shows in her work that set up the tone of this conversation today, neoliberal logic spreads rapidly and widely as the states abdicate their role in guaranteeing public health as a common good. But I think this opposition between state and state-based institutions and the market, which I think echoes Cal Polanyi's idea of the double movement, social protection versus marketization, I think in my view, it fails to capture one very important point. Which is the fact that, and this is I'm drawing a lot from Nancy Fraser's work, that regressive forces operate not only through the market, but also within the state itself, and even within civil society. So let me give some examples to clarify what's my argument here. So in Brazil, abortion is legal only in 3 cases: in case of rape, in case of risk to life, or anencephaly. But still, we have a very robust and accessible public health system, well-funded, well capitalized throughout the country, decentralized. And yet, abortion, even in those 3 cases where it's allowed, it remains extremely difficult to access. And that's not because market forces, but rather because the bureaucratic hurdles and technocratic barriers imposed by state actors. On the other hand, when you look in Colombia, which has now one of the most liberal abortion frameworks in the world, and where abortion is also publicly funded, access is often blocked by actors within civil society itself. And I think this is something that has already come up in the conversation here. But anti-abortion groups, which are part of civil society, have been setting up fake clinics using disinformation tactics to prevent access to care. So in this context and in several others, I think the binary between state and market collapses. And so we need a multi-actor perspective to understand what is at stake in advancing reproductive justice. And I think this perspective, in fact, is very much aligned with the vision of reproductive justice itself, which centers this emancipatory potential in activism, not so much in institutions. So by turning our gaze to social movements, and I think particularly feminist movements, we recognize that they are neither fully inside nor outside institutions, right? They are working with a foot within institutions, another foot outside the institutions, and trying to find where are the gaps and the possibilities to advance their visions of justice. And I think this move really allows us to see rights not just as institutional outcomes, but as productive political struggles, a shift that is essential, again, to think about reproductive justice. And then I want to turn to one example here in Latin America, which is the case of the Argentina and the remarkable work of Socorristas en Rede. So for more than a decade now, Socorristas have built an infrastructure of care through direct action strategy, which is outside, but still in dialogue with formal health institutions. So even when abortion was still criminalized in the country, they ensured that people had access to safe abortions. So against the law, they were working outside of state institutions to ensure that people would have access to safe abortion. And they also participated actively in the movement for legalization, helping draft bills, mobilize on the streets, engaging in public debate, lobbying inside the parliament. But now, since the law in Argentina, the liberalized law has come about, and people now have access to abortion up until 14 weeks, they have noticed that this law does not deliver safe abortion for everyone. Even though it's public funded, even though we have a public health system, it's still gestational limits, the fear that people have in encountering discrimination, obstetric violence, other forms of violence within formal health institutions. Socorristas have understood that their role, they still have a role to play in this new landscape within liberal abortion laws. So now, and I think particularly at the current moment with the far-right Milei government that is attacking the law, Socorristas that have been doing what is like a double move there. No, on the one hand, they have been defending this law, but on the other hand, they are also denouncing the limits of law and continuing their direct action strategy. So they are supporting people who are beyond the legal gestational limit. They are supporting people who are afraid of mistreatment or obstetric violence, or simply people who do want to have an abortion at home. And for all of this, they continue to offer care, accompaniment, and political resistance even after legalization. So I think these examples, they help us understand what Nancy Fraser has called a triple movement. No, and I was really thinking through along these categories, how we could think about abortion rights along these categories of marketization, social protection, and emancipation. So on the one hand, marketization is problematic for all the reasons that Ivana so well lays out in her work, and I think John has also showed within the jurisprudence of the UN how also I'm concluding how also this plays out in relation to frames around poverty. But then social protection can also be problematic in the ways in which social protection becomes restrictive, in which the social protection can become chauvinist, in which social protection can also deny people's autonomy and dignity. And therefore, in this third dimension that's called emancipation, we found movements that attempt to keep in check both market-driven forces, but also reactionary social protection moves. And so to defend common goods like healthcare from commodification, we need institutional forms of social protection, but protection is not always progressive, right? It can be bureaucratized, as I showed in the case of Brazil. It can reproduce racist, sexist, exclusionary logics, as we can find in several other health systems, Argentina or Colombia. So to counter both commodification and bureaucratic exclusion, I think we need vital energy of social movements who are organizing through this emancipation acts. And these movements offer the legal and political grammar that reframes abortion not only as a right, but I think abortion as care. not limited, not constrained, not surveilled, but instead rooted in trust, in collective support, and in an awareness of the structural conditions that both Aziz and Joanna spoke so wonderfully about for real reproductive autonomy. Thank you.
Thank you very much, Mariana, for this intervention. I think that you all outlined a very interesting framework from which we can start our discussion. And I would like to ask everybody who has to contribute, especially to ask our guiding question, which is, what does a robust reproductive justice legal framework look like? And what are the limits of the law? I mean, if you want to contribute, please don't hesitate to write in the chat or raise your hands. Now, while you think about, while you start raising your hands or writing in the chat, and we are keeping an eye on it, I wanted to say a few words about the campaign that has been launched in the European Union in the aftermath of Dobbs. I'm sharing my screen here. You should be able to see it. The campaign is called My Voice, My Choice. What is this about? It is a campaign that comes from civil society movement. It has been prepared in between 2022 and 2023 and officially launched in 2024. It is a citizen or popular legislative initiative for, let's call it, a bill at the level of the European Union. It asks the European Commission to act in order to provide, as you can see, safe abortion to everyone, wherever they are in the EU, since Ivana mentioned the different limits that currently exist for the European institutions to act and for EU law to act in this framework. I just wanted to mention very rapidly how the organizers framed this request, given the difficulty of placing this in EU law. So here you can see the basic demand, but what is more interesting is this part. What they are demanding is that the EU passes legislation that would create a financial mechanism that helps member states that voluntarily join this policy to provide safe abortion care for all. As you can see, there are many nuances here. Is about financial mechanism, is about member states voluntarily join, which demonstrates that, as Ivana was saying, the legal framework for doing this at the EU level is pretty patchy. Just in case you want to go a little bit more in depth, you can go and see the initiative on the official website of the European Union. And what I wanted to show you is that whenever citizens file, you need at least 1 million signatures for 7 member states in order to launch this popular initiative at the EU level. You have to justify how it fits in the legal framework of the EU and show that the EU would have a legal competence to legislate on this. And here I come to a conclusion of this little intermezzo in between our presentations and discussion. This is the way in which the promoters framed it. So they found a legal basis in Article 9 on the Treaty of the Functioning of the European Union, claiming that preventing unsafe abortion is a public health matter within the scope of the EU. Let's remember all the action of the EU on COVID. I mean, public health matter, also under Article 168. And the second legislative reference they added is that preventing unsafe abortion upholds the values, objectives, and fundamental rights recognized by the EU, not only respect for human dignity, equality, respect for human rights, and so on and so forth, well-being, etc. So these are the references that were used by the promoters of these initiatives. Of course, there might be other things, but now we are happy to take your questions, and I'm gonna look at the chat and give the floor to whoever has questions to ask.
We collect question. We collect.
Yeah, we can collect. I think let me check. Tamara, maybe? I saw Tamara wrote in the chat, so
I already asked my question, and you kind of already answered it, so that's good. I mean, I don't think as a matter of politics, the union is going to do for women what it did for COVID, but the path has definitely been shown through the COVID things.
thank you.
But I
Tamara.
could say,
Yeah.
say that, I mean, unsafe abortion, public health, of course, there's a track record of using that for international policy on reproductive and sexual health. But hey, you're the EU. Like, you could set up a new economic order in which reproduction and care is the basis of that economic. I understand that's a radical proposition, but it is one that can be made. And so, hey, if you're writing a report, I would write it. I mean, you have to put even radical propositions on a table somewhere. And
Oh,
I
yeah.
actually think,
No, I'm not
moving away. Yeah, no, that's what I'm trying to say.
I'm not
Yeah,
disagreeing, but equally, it's
it's
also
great.
going to be framed in a way that can be heard. Otherwise, it's just wasted talk. So there's a fine line here to balance between what can be heard by institutions in particular moments and what cannot be heard by institutions in particular moments. And each of us is obviously going to judge when we're making our communications how we're going to frame them. And
You got it.
I joined the webinar today mainly to make sure that I'm not missing anything. Like there's no clever line of argument, new line of argument, progressive line of argument that I've not heard. And you know, it's fantastic to hear all of these things. But the legal bases, the legal arguments in the Your Voice, Your Choice campaign are ones that have been around for quite a long time, not just for women's rights, but for also other health, access to health for vulnerable people. I can think of sufferers of rare diseases, for example. So they're not always heard by the European institutions.
But I think it's such a critical point to maintain. They are absolutely in the competence of the EU. Even if the EU currently does not recognize that.
No, listen,
the right to work, the right to social security, the right to non-discrimination, all of that is about reproductive life. So there's no way that reproductive life is not in EU competence. Yeah,
I mean, I don't think that the limits to EU competence in any health domain are actually legal. I think they're political. And, I published on that during the pandemic. So I don't think that argument will be heard by the current European Commission, because the current European Commission is very conservative, even the unit that wants to deal with women's rights and equality.
Yeah, no, I just wanted to maybe jump in here. I think that's absolutely right. I think that, as I said, we are facing a truly conservative turn, and what might have been true during COVID for other reasons will be a serious limit. But even with the campaign My Voice, My Choice, which again, I'm as a citizen of the EU, absolutely supportive on many fronts, you do see first the cautious approach when these legal bases were crafted. So we are not extending the competences. We are not interfering in member states' domestic matters. And the Commission has been always extremely careful to say, no, this is not what is happening, right? So in terms of legal and policy arguments, we are actually facing interlocutors who either are truly persuaded that has nothing to do, the abortion has nothing to do with what EU law can actually actually do, right, with their actions, or are unwilling to do it for political reasons. And I think it's a mix of both. Now, the question, Tamara, questions on care, and I really liked I really loved all of your presentations, and Aziza and Joanna really showed this idea of privatization of abortion at different levels, right? So Aziza in the US, Joanna in international law, but actually, as she said, it's not international. You're also talking a specific region, the global south, right? And then this idea that both Mariana and Joanna put on the table, which is, let's think about the economics, and let's think about abortion as care, and let's think about this new international economic order. Now, in the EU has competence when it actually is regulating care. So Tamara said, well, they don't have competence in terms of poverty and children's rights. But if we look at the ways in which the EU actually function on the ground through judicial decisions, they're very much regulating welfare and therefore poverty. So through citizenship law, for instance, they're very much regulating care through labor law and other policies. So the EU has a care strategy that, again, is very sort of on the one hand ambitious, saying we need to completely rethink that. Doesn't mention reproductive rights though. And on the other hand, it's always very cautious to say, well, we need to respect the budgetary constraints. It has to be cost effective. We're going to do public-private partnerships. And when we ask people from the commission, and I was in this position to ask them, well, what are the economics of that? They would say, well, if we propose something more capacious, so both activists, scholars, and people from the commission, they would say that will not fly. So we might, we're going to just park that argument. So we are sort of, and that's why I also like what Mariana said at the end, is that this institutional logic also limits the imagination, right? What we can actually do with the tools that we have. So I understand the turn, and I support it absolutely towards the EU and the creation of this financial fund. I'm worried that in the current context, that will not succeed, unfortunately. But overall, I'm worried that if we only turn towards institutions, we're always going to have these constraints and be in a way hostages of the political situation, and it's not good right now, right? For the issues related to gender equality and reproductive justice. Yeah.
Well, I wait to see if people have other interventions, and Mariana, Aziza, feel free you as well to jump in the discussion with the perspectives from the corners of the world that you are looking at. I will just add a couple of things. I support strongly Joanna and Ivana's argument about the need to keep pushing in spite of the political turn, which Joanna believes as is felt deeply also here. I mean, you just need to see how fewer grants for gender equality there were in the research programs of the European Commission this year in comparison to the former years. It was really, really remarkable. So there are, according to me, 2 lines of action. I consider myself an activist, more than an academic. Yet, as an academic, I do work on gender budgeting. I think it's an important perspective that the EU has adopted somehow very technically, meaning it has adopted the tools, but not the feminist critique, which accompanies the methodology, yet keeping things at a technical level and attaching it to them to financial regulation and instruments, as the promoters of the My Voice, My Choice campaign did, is a way to keep them out from the political struggle, and therefore to keep them alive to some extent. And yet there is need to push obviously at the civil society level. The EU has expanded its competencies to many fields we would never expect it would cover. So why not gender equality and reproductive justice? So I see some people have come on screen. I wonder if they have questions for us. Otherwise, I'll give the floor back to maybe Aziza if she wants to comment on the discussion.
Sure. I mean, I'd actually have a question. I haven't been tracking as closely as you all the My Voice, My Choice sort of campaign in Europe. And, you know, one of the things that really came up a lot in the sort of rhetorical deployment of the use and the word choice, which is extremely powerful, of course, and I understand the rationale for using it, has been this longstanding reproductive justice critique about, you know, the sort of individualization and the neoliberalization of healthcare. And of course, in the US context, and I think Tamara was making some reference to this, the sort of deployment of like choice in medical services has really come back to haunt us because of the way choice got deployed in a medical freedom context, in the context of COVID and masks and vaccines, and has sort of resulted in the rise of a sort of medical freedom. I'm calling it that colloquially, but you know, there might be a better term, but a sort of a movement built around freedom and choice in the context of medical care that is quite antithetical to public health evidence and best practices and structural support for healthcare. And so I'm just curious if there has been a sort of conversation traveling with the My Voice, My Choice campaign to sort of be reflective about how some of these discourses have these kind of counter effects to them. I know that it's probably a very sophisticated campaign and there is an engagement around this, but I'm curious. And of course, I'm thinking about Ivana's sort of idea about markets, you know, and the individualization of care. The way we think of it, once we introduce the language of markets, and you know, it really shifts how we understand the actors in that space. So yeah, I'm just curious to hear any reflections on that.
Thank you. This is a super interesting question. Maybe I can say a few words and then pass it on. I totally agree with your point of view, which is also, I mean, reflected in Ivana's paper. I think that the choice of the slogan is purely strategic, which is what you need to do in a campaign. On the one hand, also because they are trying to demonstrate that there is a competence based on individual rights granted by the treaties. And I think this is a stronghold. And also they are trying to adapt to the legal framework, which, as we have repeatedly said today, is definitely not a legal framework that looks at collective rights and imbalances and so on and so forth. And the last point is, this campaign is a very difficult one to organize. I don't know if you know how it works, but in order to promote it, you have to have 7 member organizations in seven people in different member states of the EU, and a legitimate legal claim to ask the EU to accept your proposal to collect 1 million signatures in 7 states of the EU. So the burden is really high. And once you achieve the objective, the campaign achieved the objective, 1,200,000 signatures and counting. Still, there is a hearing at the European Parliament and an almost discretionary decision of the European Commission on whether they will act or not. So it's mainly about, you know, raising awareness. Is a lot about raising awareness. The legal impact is not to be taken for granted yet. I think among the instruments available was one which it was worth trying. Mariana, do you want to add some comments from your perspective?
Actually, I also have two questions, one for Joanna and one for Aziza, if I may. The one from for Joanna was just like I was super curious about the last part on this development of the idea of abortion as the right to life, but but right to life as life project and this is a long tradition in the inter-American system, right? And I think, if I'm not mistaken, like the Inter-American Court was the first one to develop this, particularly in the cases of street children, and this idea that, and I've been thinking this because we have been starting to try to expand the authorization for abortion in Brazil in the case of the right to life, precisely using this inter-American jurisprudence. So I was just curious if this jurisprudence come up in the UN decisions that you are looking at, or if the UN is treating this as like a new development, like what is the conversation there? And for Aziza, you had to go because of time very quickly on the last point with mifepristone. And I was super curious about this because, again, mifepristone is not registered here. And one of the strategies that often like we think about is just like go to market actors and campaign and like show them how there is like this huge market here in Brazil. And so therefore they should come and like apply for registration. So I was just wondering if you could tell us a little bit more about this, because you had to go very quickly, because this is such a fascinating and important topic for us. Yeah, thank you.
All right, shall I give the floor to Joanna unless there are time issues? Joanna, please.
Sure, yeah, and I'll say kind of the origin of this shift or move in international human rights law. Absolutely, the right to a life plan, Inter-American Court comes through, and the most recent decision that I posted, the Fatima versus Guatemala decision released just a few days ago, cites directly now to the International Court. So I think, again, this is a body of jurisprudence that's developing, really very, very contemporary. But the other origin of this shift towards care is the fact that, and this relates back to our EU conversation, it was not the Women's Committee. It was not under the Convention on the Elimination of All Forms of Discrimination Against Women and a gender analysis that this shift to care economies and state responsibilities came. It is instead from first the Human Rights Committee under civil and political rights, and second, from the Committee on the Rights of the Child under that convention. I think it has been extraordinarily important that it has not been primarily a gender analysis, stuck in some of the grooves of abortion rights thinking in that analysis that has allowed human rights law to jump in this way. And because it's coming out of a context of child care, the context of rights-based thinking is just entirely different. Now, we might come into problems with abortion rights coming out of conceptions of child care, but what you do have is this extraordinary sense of public responsibility, not just of autonomous rights taking over and control of your life and body. Instead, you have these calls on the state to sustain the conditions of life. That comes absolutely from child's rights jurisprudence and ways of thinking, absolutely, of the welfare state, of right, an entirely different kind of logic-based structure. I don't think they know what they're doing yet in the sense of having this definitive plan of what that different normative framework will mean, but it's absolutely an origin of this move.
Thank you, Joanna. Aziza, the next question was for you.
Yeah, thank you. Mariana, I've posted in the chat a link to the article that I mentioned, which I found to be really helpful when I started, writing a bit about mifepristone and sort of politics of access here. But I think the dynamic that I was trying to talk about was that, sometimes we imagine sort of these, like the way you described, like, can we bring mifepristone to Brazil? Let's just release it into the market. This is about a market. There's sort of profit incentives. Really, this should be thought of as a purely a product to be bought and sold and paid for through insurance or state, or the state, et cetera, et cetera. But actually, what I think has been interesting about the way the mifepristone, the RU480, starting with, when it was called RU486 back in the day, like the RU486 mifepristone story has played out, is that its entry into the market has been totally filtered, as all pharmaceutical drugs, of course, but filtered through the Food and Drug Administration, which has meant that the contestation around it has really been in the register of, should this drug be approved or not, which has called on which has basically inspired conservatives to really deploy a set of arguments around mifepristone that are in the register of science, not always in good faith. I'm not saying they're making good scientific claims or good public health claims, but it's interesting to see how they focused in on, from 2002, from the early introduction of RU486 into the market, with the citizens petition that eventually kind of snowballs into some of the litigation we've had over the past few years, into a set of questions about mifepristone safety, and that those claims around safety and the ability to sort of intervene in the FDA's regulatory infrastructure shapes the market essentially for the drug. So I was just trying to connect those dots a bit. I've written a little bit about this. I can send it to you separately. But I see Riva has her hand up, and I would love to hear from Riva too.
Yeah, so we saw that Riva Siegel has her hands up, so I would give her the floor if she wants to ask a question. Riva?
Thanks. I didn't mean to cut anyone off. I just was listening to, can people hear me? Yeah.
Yes.
I was just listening to Joanna, and I was thinking that it's pretty wild to build arguments for abortion access on a law protecting the rights of the child. And just imagining putting some opponents or antis in the room, and you can just imagine where that would go. And so by free association, I guess that took me to a law that you and I once worked on, probably 10, 12 years ago, Joanna, which is to say, Germany too, and the whole skein of German and European constitutional decisions that build on the idea that one can protect unborn life by essentially providing access to, say, security, social safety net goods to dissuade women from having an abortion. Does this line of cases make sense to people, or do I need to say anything more? Am I just making sense, or is more explication needed? I don't know whether I need to say more. Yes. So, and I guess what that thought brought to mind was the power of indirection. And I was going to finish the sentence in Europe, but period, the power of indirection to coordinate or to manage access in conditions of intense conflict. And so when I sort of circled back to this campaign and all the comments that have been made about the difficulties of, is the question legal competence, or is it political competence, and what can be managed or said about the campaign, I was thinking about ways in which, whether one wants to or whether one ought to consider how the language of care can be employed in ways that the language of choice can't be employed, to be more inclusive about the values that are potentially supported here. I mean, that was the sort of chain of associations that Joanna's invocation of the child and children's rights in the middle of this conversation brought to mind. But the basic notion is we understand that there's immense conflict here, and rudimentary questions about how one builds support under those conditions, and in ways that are not necessarily adverse to matters about which we care. It's the work that I did on the amicus that Justice Alito trashed in Dobbs was all about looking to social provisioning and using that as a measure of, insincerity, bias, and stereotyping in anti-choice states. And that was the basis of our sex equality argument in Dobbs. I could build out that argument, but the bottom line is that people, as Joanna is mentioning, make decisions about childbearing because of background conditions of economic resources. The two things are not disconnected. So in any event, I wanted to put that set of topics on the table.
No,
It's both about it's about economics, and it's about compromise, both, and about the ways we talk about what matters. Sorry.
yeah, no, and thank you for also thank you for the comments, and thank you also for mentioning actually Germany, because it occupies several pages in this article. Germany in many ways, as Vera mentioned, protects, so the sort of at the core is this protection of unborn life versus the mother. So the mother is, to a great extent, the pregnant person is made to a great extent invisible and subordinate to this primary right. Now they do mention also the economic, at least in the decision 1992. That is all translated into, I'm simplifying, but mandatory bias counseling, where the pregnant person is in a way forced, or at least those who can, and it's mostly religious organizations as far as I'm able to understand the context. And if some of you are working on Germany, please intervene. So I absolutely agree that there are many conflicts here, children's rights. There's also these background conditions. And I don't know if it's a background condition, but this is something that I thought about listening to Mariana and Joanna, and something that has been on my mind, which is that, of course, we understand reproductive justice is going beyond just access to abortion, right? So whether we frame it in terms of care, whether we frame it in terms of, let's think about these background conditions and economic, and one of those is the ecological degradation. So how do we think about, and there are many ways to think about, how do we think then about this issue within that context, right? And it seems to me that reproductive justice will also seek to ensure that actually there's a wonderful article now, Aziz, if you remember the name of the author, that spoke about that, and the fetal abnormalities, for instance, that become extremely prevalent during because of the ecological degradation, and the fact that the state has no support whatsoever. First, there's limited abortion, and then there's no support whatsoever when the child is born, right?
So could I just try responding and taking apart two questions, which were the rhetorical and this question of the connection that Joanna raised between reproductive decision-making and the background conditions of economic distribution. It's clear that when Germany made its decision, the second decision, and said that one could, depenalize criminal sanctions on abortion and substitute dissuasive counseling, it was not out of any changed view about women's role in reproductive decision-making, but it was under conditions of German reunification and the need to make a political compromise, et cetera, but the logic of that decision has spread. It's spread through Europe, and it's transformed over time. And even though I don't have the language competences to understand all the different forms it's taken, it is my understanding that in the Portuguese decision today, or in Spain's decision now, that it's result open counseling, it's not dissuasive in the same forms, and it's justified on fairly egalitarian and gender respecting grounds so that it's not the same logic as the original decisions. And therefore, we can see that it's come to merge with a much more, if you'll excuse my saying so, a more feminist or more gender egalitarian kind of reasoning that was in the original German opinion. So that's one thing that I was referring to there. But the opinions still refer to protecting life as a rationale for providing the counseling, even as they are infused with this other gender egalitarian form of reasoning. And why are those two forms of reasoning fused together? I think it's because they're conflict accommodating or ameliorating, or they're allowing different elements of the society to find elements of the decision that make it acceptable to them in some way. And I don't think that that's a wrong. I mean, I can think as a feminist that it's probably a better thing that people find elements in their constitution that they can recognize as respect worthy. And I think that courts need to find ways to do that, or we wind up in places like we are, for example, in the United States. So bottom line being that I don't think that project of, and I was one of the people in the US who found Casey more respect worthy than others, because I think when societies are really divided, courts need to find a path through that deals with decision making in ways that takes account of extreme social divisions. But putting all of that aside, I just wanted to put that on the two different elements. One, that decisions get made in matters of childbearing that are deeply connected to background conditions of distribution. And two, when courts talk about how constitutions do or don't bear on reproductive access, they're also trying to deal with, political divisions. And I think both of those are happening. And when Europe is talking about this campaign, you all can be thinking about whether you want to be presenting what you're doing in ways that are more or less tolerable to people you really don't agree with. That's the question you have.
Thank you. Good question. I will return the floor to the speakers for a final round, because we only have 3 minutes to go. So
I apologize.
maybe just some final thoughts. Aziza, you need to go. So if you want to say something, you were addressed the question on the digital dimension, but just please also.
Yeah, sure. I tried to answer it in the chat. I really appreciated the point that Tamara was making about sort of all the new the ways mifepristone is being governed. And I'll just conclude by saying thank you so much for having me and having this wonderful conversation. And it's such a pleasure to be in conversation with so many wonderful, brilliant people thinking about all of these hard things that we're all grappling with right now. And so thank you so much.
Thank you. Mariana, Jana?
Yeah, so I'll join Aziza in thanking for this amazing conversation. And I think I would just end on this note, like echoing what we've been saying before, but what Riva was saying too, that I think the language of care can really do a lot of service to us right now. And I think this language of care has, at least like in my context, it hasn't been used so far to talk about abortion. So we have used the language of social justice, we have used the language of health and access to health, but the language of care and care as such, as a common good, as a social good, and something that we own to other people beyond those who are most close to us, I think it can really help bridge so many divides, because it is associated with all the care work that we are doing within the home, but all the care work that we do within schools and outside and in workplaces. So I think it really helps to taking abortion out of the siloing and showing that the work that's being done through abortion is the work of care. And then for me, like feminist movements in Latin America, I think they have been really keen to expanding this language and make use of this language, which I think goes really beyond like the language of right, but also the language of health, which I think it's still limiting because it is still sets ourselves again like within this realm of medicalization, which can also be as constraining as marketization. And we didn't get a lot in the conversation here on medicalization, but I think it's as constraining as marketization. Yeah. Thank you so much.
Thank you, Mariana. And I think Joanna and Ivana need to close the circle, and we have come to an end. Please.
No, I'll let Joanna talk. I just wanted to thank you so much, Joanna, Mariana, Costanza, everybody who contributed. This was a wonderful conversation, and I look forward to more conversations such as this one. So Joanna, please conclude.
Great. No, thank you so much. And I'd love to see you, Riva. But I think the conversation is about talking in ways that are unfamiliar. You know, I started with this idea, and Riva and I love the art of language, the hidden value of feared things. It's true. The rights of the child. But then you start looking, and what does it give you? It's giving you all of these ideas of care, but also concepts of dependence, for example, of vulnerability. But the human rights authorities flip them. And we do need a concept of dependence if you're going to work with the economic dependence of motherhood. And that's exactly what the human rights authorities did. I don't know how conscious it is, and as you said, how much they are working in a strategic way, but there is definitely either through their own sort of indirection in a sense of being directionless of strategy, they are stumbling, I think, onto something that we as advocates need to grab onto and make into formal legal arguments. Absolutely. They found something that we weren't looking there and we didn't find. But I think they found it, and I think it's for us now to pick it up and run. So thank you again for the conversation, and I hope we can do a little more of that running together.
And we like very much to finish with that line, Joanna, because it's very concrete wishful thinking, and I hope we can address it. Thank everybody for being here, and especially to our speakers and the people who contributed. And stay tuned. We're gonna have more seminars. Goodbye.